Good afternoon, everyone. Thank you for joining us at such short notice. We wanted to talk about what is happening in the immigration world amongst all this chaos that has been caused by this little virus, COVID-19. So let's get started. Um, but before we do that, quick housekeeping rule. Please understand that this information that we are providing is at a very generic level. You should be contacting your counsels for case-specific details and action items. Now, we are seeing a couple of changes from USCIS's side. First step on as of March 18th until April 1st at this point, all the field offices and appointment service centers are closed. What that means is you wouldn't be able to go in for biometrics. There wouldn't be any green card interviews, nationalization interviews, the oath ceremonies, all that have been postponed until April 1st at this point. USCIS will be sending you new appointment letters to appointment letters. Now, what happened is on March 17th, midnight of March 17th, actually, we saw that USCIS published this announcement saying that they're closing all service centers, field offices, and appointment service centers. So there were people who were supposed to go in for biometrics or interviews who couldn't go because of this. But the USCIS already has mentioned that the failure to appear for these would be excused. So there is no harm, no foul. Everything is okay. Now, as part of a humanitarian effort that USCIS is making, they are allowing people to apply for extension or change of status if your I-94 has expired. Let's take an example. A person comes in on a B1 visa and is not able to go back home because of the border closures. They would be able to apply for an extension. And please be aware that you should be citing COVID as a reason. Reach out to our office in case you have any question. Let's talk about this whole economic hardship to F1 students. So the students that in consideration here are students who are actually enrolled in school, attending classes. They're not on OPT, CPT, or STEM OPT at this point, right? So those students, if they are able to show economic hardship, which is a higher standard, they can apply for EADs, that is Employment Authorization Document, upon approval from their DSO to work off campus. So let me give you an example here. If, let's say the student is here, a student or their loved ones get infected by this virus, they've racked up bills. Now they can show the proof and reach out to their DSO, get their I-20, a special I-20 that has to be signed, and apply for this. Again, I have to reiterate, the standard, economic hardship standard is pretty high. It is not as simple as just throwing out an 765 at this time. Expedited processing. So again, in scenarios like we just explained, wherein a person is going through financial hardship because of this, they can request USCIS to expedite the processing of their paperwork. Now, this does not apply to H1, really. The employer can try, but usually they don't accept it. But it applies typically, it works very well when it is H4 EADs, L2 EADs, in the EAD card scenario. What you would require is, there is no form to fill, there is no fee to be paid. You require the beneficiary to actually pick up the phone, patiently talk it through the USCIS officer on the phone, and ask them to expedite. You get relief by a couple months. Premium processing. So before we talk about premium processing, let's take a step back and see what is happening in the CAP fiscal year right now. No numbers have been determined yet. We are not seeing any applications being picked in our office, but we'll certainly keep you informed if you have pre-registered through us. We should have the final certifications, that is, we'll know who all got picked in the lottery or the pre-registration by March 31st. And from April 1st, you can go until June 30th, you'll have the time to actually make the filing. Now, When we come to premium processing, please note that it has been stopped for all kind of application. That is, you cannot send a 907 anymore until further notice. Now, last year with the cap, USCIS tried the staggered approach, and which they believe helped with the processing time. What they did was they allowed for premium processing for change of status applications. First, on a particular day, and a month or so later, they allowed premium processing for consular petitions to be enabled. Now, they are trying the same approach this year, wherein the change of status petition can apply for premium starting May 27th, while the consular petitions can start requesting premium from June 29th. Please note, the cap subject petition, the premium processing has not been stopped, not for the COVID purposes, but as a general policy to handle the processing time. Whereas all the other cap exempt petitions, wherein there's a change of employer, amendments, extension, I-140, so on and so forth, it has been stopped because of the COVID reasons. Employees whose I-94 has expired but have filed an extension, you would have to be worried about the 250-day rule. But my guess at this point, and this is just a guess and nothing more, is that they would be reopening this by September. Fresh ink requirement. So typically, beneficiaries, employers, and attorneys are required to sign in ink of certain forms such as the I-129, 539, 765, 140, 485, so on. USCIS, to allow for the whole social distancing, have allowed for scanned or e-scanned e-signatures, faxes to be used. However, please do save the signature pages, the actual signature pages, with you safely, because they may be requested later, and my guess is they would be requested at the time of the RFE. Now, a housekeeping item, to allow for social distancing and to do our part, our office is ready to write the check to USCIS once the USCIS fee is ACH to our account. Call our office or email us, and we will give you further information on that. Now, a constant question that I'm hearing these days is when the employee has to work from home. Can they work from home, right? It seems to be the norm. Shelters are in place, you need to work from home. Is an amendment required? Now, the answer, like my son says, is yes, so maybe so. So let's take a couple examples. When you can work from home without an amendment when your home is in the same MSA. So let's take an example. You are working for Citigroup in Irving, which falls under the Dallas, Collin, and Tarrant County MSA. You live in Frisco, or the beneficiary lives in Frisco or in Irving itself, then no amendment is required. However, if the situation is a little different, wherein the beneficiary does not live in the same MSA as that of the end client or the workplace, then 20 CFR 655-735 allows for a person to work from another location for 30 days up to a max of 60 days in a year. So we'll work on the same example that I gave. Person works at Citigroup in Irving. However, the person is telecommuting from Houston. So not telecommuting, he's commuting from Houston. He comes in on Monday, leaves on Friday. Then a person can work from home from Houston for up to a 60-day period, 30 days or a 60-day period without an amendment, right? However, you have to make sure that there's no other changes and there's a desk available for this person at Citigroup that he or she can come back to, and the tax treatment is the same. Now, beyond the 60-day period, unfortunately, we do have to wait for DOL to clarify, and I think that would depend on how things pan out. Benching. So benching is a common phenomenon wherein the employer, the project is over and the employer makes their employee wait it out until they get the next project, and during which time they don't pay them. It's a strict no. You can't do it. Just don't do it. Now, so during the period of COVID-19, the rules for belching still apply. You still have to pay the beneficiary what you said you will pay them as per the LCA. Now, if you decide to change the wage, right, then your amendment is required. Now, let me give you an example. Beneficiary was working at client at Citigroup at 60 an hour. Now Citi came back, asked you to reduce the wage to 40 and the pay rate to 40 an hour. If you decide to bring it down to 40 an hour, an amendment is required. Otherwise, the employer would have to make up for the difference, because you have to pay what is said on the LCA. Now, to help, to help the community and our clients, our office has a revised fee structure for amendments. So please do contact our office and we can talk through this. A client of mine asked this question regarding this $1,000 check, the stimulus check that the government is giving to help the economy grow. The question was, hey, would this $1,000 check be considered as public charge? Please remember, public charge, there are certain things that get classified under public charge. Accepting those public benefits would be detrimental to a person's immigration intent and status. Now, the $1,000 at this point is not considered public charge. However, before the beneficiary goes in and encashes it, I highly recommend that they talk to their CPA to make sure that it isn't. Right? Now, there's a new FMLA and COVID rules that have been instituted for the employers starting April 2. This is part of the Families First Coronavirus Response Act, and the links are being provided in this presentation. Please do talk to your attorneys who practice employment and labor laws for further clarifications, because it appears to impact employers who have less than 500 employees. So from what I understand, speaking to our to the members in the legal community, the act is of two parts. Step one is you're required to give them 3 weeks of paid leave for them, for the employee, or if the employee suffers from COVID, or if the employee has to take care of a loved one who is suffering from COVID-19. The employee can also leverage up to 12 weeks, right, of FMLA. And again, I highly recommend that you need to pay. You need to talk to your attorneys who practice employment and labor-based law to get it clarified as to how it impacts you. Denials and I-94 has expired. Now we are seeing this is particularly an issue when the borders are closed. At this point, we know that the borders are closed to Mexico, Canada, for non-immigrants especially, as close to Mexico, Canada, India. I think China has it close too, but I'm not too sure about that. So in this case, what does a person do? You don't want really to be in no man land. So one of the things that you should be considering, and again, it has to be considered on a case-to-case basis, is the non-pro-tunc. Non-pro-tunc means this for that. That is, can you consider this for that, everything else being the same? Now, if you're doing non-pro-tunc, the project cannot change. So you cannot say, hey, when I filed the initial petition, he was with Citigroup, but now the person is going to be Bank of America. So can you do this non-pro-tunc? That will not work. The project, if there's a denial from Citigroup's petition, you'll have to still, if you decide to file it non-pro-tunc, you'll have to still file it from the Citigroup's LC that was used. Now, you can always file for a temporary change of status petition from a whatever status to a B1, B2 to get relief until such time that the beneficiary can leave the country. It's just a short-cap measure to maintain status. However, If a person is without a 994, please ask them to be careful at this point, because drunken driving, shoplifting, driving without a license, getting pulled over for a light that is missing in their car, or driving for fun during the sheltered in hours, that may cause them to be arrested and put through the deportation process. And the deportation place, the deportation jail is the last place where they really need to be at this point. So please ask them to be careful and stay put in their places. Now, you really need to consider prompt responses to the RFEs, especially when the clients are really shutting down the projects because of COVID-19. Our offices is promising at this point a 2-day turnaround, provided we have all the documents provided. I-9s. So traditionally, I-9s require that the HR who is signing on behalf of the employer physically verifies the supporting document. However, to allow for social distancing, USCIS has said that the HR can actually verify it through Skype or through scanned documents. However, I highly recommend that you write a memo. And a memo is nothing but a dated letter from the HR here that says that what he or she verified, what document, and how it was verified. E-verify rules are still to become complied with. There is no change, and it's a web-based portal. Department of Labor and its changes. Department of Labor, not to be left behind, is trying to catch up and try to help. At least they are trying to help in this situation of COVID-19. And one of the things that they have said is posting at home, if someone is working from home, is not required. It is enough it is posted at the headquarters, and electronic posting, that is through SharePoint and other mediums, would be accepted. Again, please remember, you cannot reduce wages without a new filing. And we are also expecting perm determinations to be delayed due to resource constraint. If suppose you are under an audit and you need more time because you cannot go into work or otherwise, you can ask for an extension citing COVID-19. Last but not the least, some housekeeping items from our side. Our offices are closed for people to come in, drop off the package, or come meet with us. We are all under shelter in place at this time. We're working from home. There will not be any delays in filing your petition. It's business as usual for us. In case of you have questions, concerns, please feel to email us or call us, and we'll be more than happy to answer your questions. Please be safe and stay healthy. Thank you, everyone.